panel. This group constitutes the remnant, and it's actually a very large remnant. I'm happy to see that so many people have stuck around for the afternoon. The good news for you is that in return for being the remnant, we have, in the grand academic tradition, wine and cheese following this panel. So, but you have to stay for the whole thing. So if you stay for the whole thing, we will reward you. And the other bit of good news is that this is going to be a really fascinating panel. So it's a good thing that you stuck around. So we've heard from people today who think that the Missouri Plan is terrific, and we've heard from people who think that it is not good, and we've heard from people who think that it's kind of like democracy in that it's the best of a bunch of bad options. This panel is going to consider, what do we make of all that? Is this something that we should jettison? Is it something that we should keep as it is? Is it something that we should tweak? So I'm interested to hear what all these folks have to say. Our panelists are incredibly distinguished. The first speaker will be Professor Stephen Ware of the University of Kansas Law School, graduate of the University of Chicago Law School. Professor Ware has taught at Cumberland Law School of Samford University in Birmingham, at William and Mary, at Ohio State, at Alabama, and at Hamlin. He has numerous books and articles, largely in the alternative dispute resolution area, which is, of course, something that we're famous for at our law school. He has several pieces on judicial selection, including most recently an article called Selection to the Kansas Supreme Court that's been published in the Kansas Journal of Law and Public Policy 2008. Professor Ware was incredibly helpful in getting this symposium organized when the law review editors, Matt Feldhaus in particular, came to talk to me about the topic. I really knew very little about the Missouri Plan, and I recalled having seen an article that Professor Ware had written, and we had met for about 30 seconds at a restaurant one time, so I thought, well, he seemed like a nice guy, let's call him up and see what he has to say.
After 30 seconds, he changed his mind.
No, we actually scheduled a little conference call, and he was very, very helpful, and many of the folks that we heard from today were his suggestions, so we're thankful for that. And he's going to present a paper called The Missouri Plan in National Perspective. Our second presenter will be Professor Brian Fitzpatrick of the Vanderbilt Law School. He's one of the less distinguished members of the panel today. He was graduated only first in his class from Harvard Law School, clerked for Judge Scanlon, and then for Justice Scalia, practiced law at Sidley Austin in Washington, D.C., advised Senator Cornyn on judicial nominations, was an Olin Fellow at NYU, and joined the Vanderbilt Law School in 2007. Professor Fitzpatrick has written pretty extensively on the Tennessee judicial selection plan, including 2 articles in 2008, one in the Tennessee Law Review, Election by Appointment, the Tennessee Plan Reconsidered, and in the Memphis Law Review, Errors, Omissions, and the Tennessee Plan. The paper he'll be presenting to us today is The Politics of Merit Selection. Our third panelist is Chief Justice Laura Denvir Stith of the Missouri Supreme Court. Judge Stith is a native Missourian. She attended Georgetown Law School, became a partner at Shook, Hardy & Bacon, and then founded their appellate practice. Her father, I learned, was the mayor of Clayton, Missouri. So she's really a Missourian. She was appointed to the Missouri Court of Appeals in 1994 and then to the Missouri Supreme Court in 2001 and became Chief Justice of that court in 2007. Judge Stith has been very active in the bar and legal community. There are extensive details in the biographical materials that you have. I'd encourage you to take a look at that. It's quite impressive. Something that I found interesting when I was doing a little research on Judge Stith is how legal her family background is. She has a sister who is a lawyer for the EEOC, a brother who's a law professor at Valparaiso Law School, a sister who's a law professor at Yale Law School, a brother-in-law who is Judge Jose Cabranes on the Second Circuit Federal Court of Appeals. I can imagine that you have some pretty exciting dinner conversations at your Judge Stith.
We're never at a law school.
Right. She's going to be presenting to us a piece entitled "The Missouri Nonpartisan Court Plan, the Least Political Method of Selecting High-Quality Judges." Right. Commenting on these terrific papers, have we decided who's going first? Okay. Professor Michael DeBow of the Cumberland Law School at Samford University will be presenting first, or commenting first. Professor DeBow is a Yale law grad, clerked for Judge Ken Starr, did antitrust work at the Federal Trade Commission and at the Department of Justice, where he was an assistant to now Judge Douglas Ginsburg, who knows quite a bit about judicial selection himself. Professor DeBow is a native Mississippian from Tupelo, Mississippi, and that we learned this morning that Mississippi was the first state in the nation to adopt judicial elections for all judges in 1832. Appropriately enough, one of Professor DeBow's publications is entitled "The Case for Partisan Judicial Elections," so he's sticking to his Mississippi roots. The second commentator is Professor Mary Volcansek of Texas Christian University. She is our political scientist on the panel, PhD in political science from Texas Christian. She is now a professor of poli-sci and the dean of the College of Humanities and Social Sciences at TCU. She is a prolific scholar, a number of monographs and edited books, in addition to many, many articles and book chapters. Looking just at her monographs, she has books on judicial misconduct, judicial impeachment, judicial selection, and judicial politics. She knows a lot about how judges are selected and how they think and how they misbehave on occasion. She is, I believe, and I didn't check this with you, but just from looking at her CV, she seems to be a bit of a comparativist. Has published quite a bit on European systems of judicial selection, and it looks like Italian systems in particular. One of her most recent articles is entitled "Appointing Judges the European Way," and it is in the Fordham Urban Law Review, 2007. So we will get started with Professor Ware.
Thank you for being here. I hope it's not just for the wine and cheese. And I want to especially thank everybody at the law school who did so much work to put together this terrific day. I know for the students especially what a tremendous amount of work you did. And especially want to thank Matt and Stephanie, the two students I dealt with the most. Just a tremendous job. What I've got here is the Missouri Plan in national perspective, and it's the perspective I sort of can't help but bring to the issue. I'm a New Yorker who's licensed to practice law in New York, and I then, when I moved into law teaching, taught for 10 years at a law school in Alabama, Cumberland, and then now have taught for 6 years at University of Kansas. So if you think about those three states, New York, Alabama, and Kansas, I can't say I'm particularly well rooted in any of the three, but sort of my experiences are an amalgam, a combination of seeing the three. And each of those three states has very different legal cultures, but also relevant to our topic today, different systems of judicial retention. There's basically three systems of judicial selection and retention used around the country, and those three states I happen to have lived in, one in each of the three categories. So I think I do bring in my life experience as well as my scholarly research a national perspective to this issue. And where I start with that is with, I guess, the saying that it's easy to criticize, but what do you got that's better? I guess is where I start. And certainly when it comes to judicial elections, there's a lot to criticize. It's easy to criticize because there's a lot to criticize. But I think to be constructive, you have to come up with an alternative that you're willing to defend that's better than judicial elections, than electing judges. And I think it's especially important that those who are critical of judicial elections not be allowed to get away with a quick endorsement of merit selection without getting into the details and really specifying what that means. So that's my goal for the next 15 minutes or so, is to get into the details and to really see what it means in the goal of having everybody think critically and carefully about the alternatives as they're used around the country in the 50 states in our nation. Okay, so I guess what I should do now is see if this clicker works. Yeah, it does. Great. The Missouri Law Review's title for this symposium is, as I guess was Dean Dessum said nicely earlier, about mulling over the Missouri plan. But then the second half of the title is a review of state judicial selection and retention systems. And I think that's hugely important to distinguish selection and retention. How you put a judge on the bench initially versus what decides how long the judge stays on the bench, he or she stays on the bench. Those seem to me to raise some very different issues and ought to be analyzed separately. So what I'm going to do is focus on the selection half of this and then turn to the retention half of it before trying to tie it together. Okay. Yeah, it's working good. Okay. Basically, three methods of selecting judges. And you see again up at the top, I've got judicial selection. Right? This is not retention now. We'll get to retention in a few minutes. Selection is my focus now. How do we initially put judges on the bench? When you look at the 50 states, there's a few little quirks, but most states fit fairly well into one of these three categories. And I start with the most common method of selecting Supreme Court justices. Here I'm speaking about states' highest courts. So all the data I give, all the quantitative statistics I give are about states' highest courts, not trying to be comprehensive and cover the lower courts in states. But when you look at high court selection around the country, the most common method is the contestable election. Contestable meaning two or more candidates can be running for the same position on the court, just like two or more candidates can run for governor or senator or any other office. This is the most populist method of selecting Supreme Court justices because it puts the power directly in the hands of the people, the voters. The second method of Supreme Court selection I have up on the screen there is the one we're all familiar with from the U.S. Constitution, selection method for federal judges, where the president nominates somebody, but that somebody doesn't become a federal judge unless the U.S. Senate votes to confirm that judge. And about a dozen states around the country use that method. I call it the Senate confirmation method because it's the governor nominating, but then that person doesn't join the court unless the state Senate or similar popularly elected body votes in favor of confirming that person. In some states, it's both houses of the legislature have to vote to confirm. A couple states in New England still have a governor's council, I guess something that's been around since the 1600s or something. But again, a popularly elected body that votes to confirm the judge. Senate confirmation system, not as populist as contestable elections, because the power is not in the hands of the people themselves, but rather the people's elected representatives, the governor and state senate. People have mentioned President Andrew Jackson, associating him with contestable elections, And so if that's a good sort of historical reference point for the first of the three methods of selection, then I think the framers of the U.S. Constitution are the ones to associate with the second method of judicial selection up there. And just as the framers of the U.S. Constitution were sort of that view of democracy that Professor Lambert mentioned a minute ago of, well, it's not great, but it's not as bad as the alternatives. Framers of the U.S. Constitution clearly had that view that we want the people ultimately to be sovereign, but we want to temper the perhaps rash or ill-considered views. People may get caught up in the passions of the moment, so we want to set up a structure of government that mediates and cools those kind of passions of the moment. And so it's a more sort of long-term reflective popular sovereignty, I think, is the gist of a lot of the U.S. Constitution. And you see it in the Senate confirmation system in picking federal judges as well, instead of having the people have their representatives make these decisions. So although Senate confirmation is not as populist as contestable elections, it is egalitarian. And when I say egalitarian, I mean consistent with one person, one vote, consistent with basic equality of political rights, in that a lawyer's vote for governor or state senate is worth no more than any other citizen's votes. There's no one group that has greater power in voting for a governor or a state senate. There are, though, many states that have used this Senate confirmation system in a way that tinkers with that last point, that egalitarian point. Some states, I'll pick New York as an example, require their governor to pick for a nominee for the state's highest court, require the governor to pick only someone recommended by a nominating commission. In other words, unlike the President of the United States, who can nominate anyone to be a federal judge, in several states that use this Senate confirmation system, the governor is restricted into picking only someone recommended by a nominating commission. And in some of these states, like New York, the nominating commission has a requirement, constitutional requirement, that there be a certain number of lawyers on the nominating commission. So it's what I call the lawyer's quota. There's a quota for lawyers on the nominating commission. No other occupational group or other group has a similar quota on the nominating commission. In other words, New York favors lawyers compared to other citizens insofar as guaranteeing lawyers representation on the commission and not guaranteeing any other group similar representation. Now this movement from equality, from egalitarianism to elitism, to giving power to a small elite segment of the society, the bar, is a small movement in a place like New York because the nominating commission and its recommendations to the governor are, how shall I say it? Although there's lawyers on the nominating commission, although that's a requirement, the crucial question is who appoints the commission? Who selects the commission? And this is where I say earlier it's good to get into the details, right? It's too easy to just say, well, I don't like elections, I like merit selection, right? If you get merit selection, you get to commission. Who picks the commissioners? Who picks the pickers? That's sort of the crucial question. And in New York, for example, it's popularly elected officials who pick the pickers, who appoint the commission. It's the governor, it's the legislative leaders, and it's chief judge of the highest court who, although not popularly elected him or herself, has gone through this process of governor and state senate approving. So there is sort of indirect popular control over the selection process, including which lawyers are involved on the committee. Now, other states go farther using the Senate confirmation system, where actually the bar gets to pick some of the representatives on the commission. And this is where I was really struck when I first learned about this several years ago. I thought to myself, where else do we have this in our federal and state government, that we have public officials, people exercising this important governmental power of, in this case, restricting who the governor can appoint, where the selection process isn't one person, one vote. It's lawyers get power and other citizens don't. Lawyers get more power in selecting these folks than other citizens. But where states do it that way and still have Senate confirmation at the back end of the process, this is what I would call having some elitism, giving lawyers more power at the front end of the process, but having it tempered with populism, Senate confirmation, or egalitarianism at the back end. Then you move to the Missouri Plan states, which have the elitism at the front end without the Senate confirmation at the back end. So the Missouri Plan states are the most elitist of any of the states' selection methods in terms of concentrating power in the bar. So here's just a quick breakdown on who's got the power in the three systems. And then here's the more detailed one. This is kind of like going to the eye doctor, I know, particularly if you're on that side of the room. It may be hard to see. But you see, I've got a focus on appointments. That's my title up there, focus on appointments. And so I lump all the contestable election states together, the 22 states that use contestable elections. And I break down the other states really in terms of how much power it gives the bar. How much power the bar has in selecting Supreme Court justices. And I can go into more detail separating out all the different states, but the one that I want to call to everybody's attention is the middle ones I have there. I call it Senate confirmation, and then the ones down at the bottom I call Missouri Plan. And the Senate confirmation states, as I said, those are all states where whether or not they have a nominating commission, they have, after the governor nominates, they have this Senate confirmation at the back end. Whereas the Missouri Plan states, those are the ones where the governor's the last step in the process. The governor's the last step in appointing judges. The only check on the governor's power is the nominating commission. And you see I have a line there between soft Missouri Plan and hard Missouri Plan states. That the soft Missouri Plan states, yes, they have a commission that's the only check on the governor, but in those states there's at least some role for publicly elected officials in selecting the lawyers who are on the commission. Whereas the hard Missouri Plan states, those are the ones where popularly elected officials don't get to select or play a role in selecting the lawyers on the commission. It's the lawyers in the state who select the lawyer members of the commission, the members of the bar in that state. Okay, now that I've said all this, usually what comes up in a group of lawyers when I'm talking about this topic is, am I comfortable with populism and elitism as terms to describe these different systems? And my answer to that is just to say, I don't think populism is all bad. I think there's some good to populism, and I don't think elitism is all bad. I think there's some good to elitism, and I think we should all feel comfortable saying that. I think we should all feel comfortable at the county fair or wherever we're talking to regular folks to say, you know what, there's something to populism, there's something to elitism. Where that takes me is somewhere in the middle of this continuum. If I got to pick, I'd want a state to be somewhere in the middle, because I think there's some value to the populist insights and to the elitist insights. And so I think the framers of the U.S. Constitution struck a pretty good balance here. But that's just the selection side. I promised I'd get to the retention side as well. On the retention side, I think now the terms independence and accountability really come to the fore. When you're talking now not just about, when you're talking not about how a judge initially gets on the court, but how it's determined whether a judge stays on the court. And here, my own preference is more towards the independence side than the accountability side. And so my criticism of the Missouri plan is not just on the selection side, but also on the accountability side. I don't think retention elections do enough to protect judicial independence. And where this takes me, I guess, is what Professor Shotland talks about, plea for reality. And he's been experienced in these debates about judicial selection and retention for a long time. And I hear similar things from Professor Paul Carrington, who unfortunately is not here today, but another very distinguished scholar who's been in this topic of debate for a long time. And he says, you know what, we lawyers, most of us, we don't like judicial elections. He says, you know, Steve, you're not new in not liking judicial elections, but let's get real here. They're around. They're around to stay. We can't do anything about it. Let's just try to make the best of judicial elections. Let's try to soften their negatives. And my response to that is, well, I don't know if we've really tried to replace judicial elections with something that gives the populist side their due at the initial selection stage. In other words, if you're advocating for a Missouri plan at the front end of selection, then I think you're going to have a hard time dealing with the desire for some kind of populist election front effect at the back end, at the retention stage. And so what I'm kind of hoping is people will say, you know what, we can have a grand bargain here, right? We can have the Senate confirmation system at the front end, get a little bit of populism there, not too much, and then we'll be able to do away with judicial elections at the back end. So maybe that's a naive hope, but that's where I am on this. I thank you for your attention, and I look forward to the rest of the discussion. Thank you.
Well, I want to echo what everyone has said today, and thanks to the law school, to the Law Review for putting on such a fantastic event. I've really enjoyed being here, and I'm very impressed with the law school and with the Law Review members who work so hard to make all of this happen. You know, this event has also been very informative to me because we've heard a lot today about, you know, almost every speaker has basically said that the question of where you come down on judicial selection depends on how you balance judicial accountability and judicial independence. It's been my view for several years that those questions are not actually the best determinants of where you come out on judicial selection. My view has been that where you come out on judicial selection basically comes down to two questions. How much you believe in legal realism and how much you like democracy. And this has been very informative to me today because I had thought that pretty much all of us bought into at least the basic premises behind the legal realism movement. And today, I've learned that a lot of people still resist some of the lessons of legal realism. And I found that very informative, and I'm going to talk a little bit about that today in my presentation. And I'm going to talk about it in the context of asking the question, do merit systems eliminate or reduce the role of politics in judicial selections? This is one of the major claims of those who support merit systems, is that we reduce or eliminate politics if we go with a merit system. And I'm skeptical of this claim. And and I'm going to describe to you why I am skeptical. The first thing, though, that we need to know in order to analyze this claim is, what do proponents of merit systems mean when they say we're going to take the politics out? And so in my experience in discussing this matter with the proponents of merit systems, I've come up with two versions of what politics means. So one version, this is I think the weaker version of the claim, is that politics means politicking. So if we go with merit systems, we're going to have less politicking, because judges won't have to raise as much money. They won't have to lobby as many people to get their jobs. Instead of thousands or millions of people in an electorate, they've only got to lobby the 12 people on the selection commission or the governor. That's cheap, and there's fewer people, so there's less politicking. Now, this version of the claim, I think, is absolutely correct. So merit systems lead to less politicking. I'm just not sure that that gets us very far in the debate over judicial selection, because less politicking also often means less transparency. If you know, one thing about contested elections is it's out in the open. We see it, you know, in all its ugly details sometimes out in the open. When, you know, we go to lobbying commission members or governors, it's less visible. And in addition to that, you know, merit systems may reduce the politicking compared to elections, but they may not reduce the politicking compared to other systems, such as appointment by elected officials. And so if all we want to do is reduce the politicking, regardless of what substantive changes that may cause in the judiciaries we select, merit selection may do that to some extent vis-a-vis elections. But there's another version of this claim, which I think is a stronger version of this claim, which is that eliminating politics means we want to take out any consideration of the judicial candidate's political and ideological beliefs when we're deciding who to put on the court. We either want to eliminate that as a criterion for who gets on our courts, or we want to reduce that as a criterion. Now, this is a stronger claim about merit selection. This is a substantive change in who gets on our courts, not just a formal change of process. It's a substantive change of who might end up on our courts. But the question is it realistic? Is it realistic to believe that if we switch from elections or elected officials picking our judges, is it realistic to believe that these merit commissions who nominate names to the governor, is it realistic to believe that they won't care about the political beliefs of the judicial candidates that come before them? And in my view, it is not realistic. And I'm going to tell you why. Number one, so the political beliefs that judges have matter. They matter to the decisions that judges make. We know this. Justice Brennan, Justice Scalia. They're both extremely bright, extremely capable people, but we have a pretty good idea where they're going to come out on lots and lots of legal decisions. It's because they have different viewpoints. They have different worldviews. They have different priors that they bring to them, that they bring with them when they come to the bench. Politics matters to legal outcomes. There's an excellent book written by Cass Sunstein entitled Are Judges Political? I encourage you all to read it. It's very readable. And of course the conclusion that he comes to is yes, of course they're political. Of course politics has some role in legal decision making. Now it doesn't have a role in all legal decisions, right? So a lot of times the law is crystal clear. There's no room for disagreement. But sometimes the law isn't crystal clear. And there is room for disagreement. And this is what the legal realists taught us 100 years ago, is that the law is often ambiguous. You know, a lot of times the law says you can do something that's reasonable. What does that mean? Different people are going to have different views of what's reasonable. The legal realists showed us that statutes, constitutions, precedent, all these things can be ambiguous. Not because we're not smart enough to figure it out, but because language is ambiguous. It's not math. It's words, and it's ambiguous. And for these reasons, judges have discretion. They can't decide cases entirely on the legal texts that come before them. And so something else is explaining their decisions. And one of the things that political scientists and legal scholars have demonstrated over countless studies, over countless years, is that one of the things that's associated with legal decisions is the political beliefs of the judge that renders those decisions. And that's what Cass Sunstein's book demonstrated for a lot of different types of cases on the federal courts of appeals, and there's lots of other books and lots of other articles that make these same findings that political beliefs influence judicial decision making. Now, I didn't think that this particular claim was all that controversial, that sometimes politics matters. Not all the time, again, it's sometimes. And if politics matters sometimes to legal outcomes, then we have to ask ourselves the question of whether the people that select judges are therefore going to care about the judge's politics. And I think the answer to that is that the people who select judges will probably care about the judge's politics because the people that select judges probably care about judicial outcomes. I mean, voters care. Voters care whether there's affirmative action or not, abortion or not, the death penalty or not. Elected officials care. They care about whether there's affirmative action, abortion, the death penalty, et cetera, et cetera, et cetera, how hard it is for corporations to do business in the state, et cetera, et cetera, et cetera. The people that select judges often care about outcomes in cases. Now, I guess in theory it's possible. It's possible to find a bunch of people to select judges who wouldn't care about outcomes in cases. We could, for example, maybe go to a foreign country, import some people in for a week to take a look at some candidates, and then have them go back to their country after they've selected which judges to put on the bench. But that's not the system we use in this country. We use people, voters, elected officials, who are affected by legal outcomes. And so the question for merit selection, in my view, is are things different? Are things different when we go from voters and elected officials to the merit commissions? Do the people who sit on these commissions, are they going to care about legal outcomes when they make their decisions? And I think there's lots of reasons to think that not only will they care, but they'll actually care more than voters and elected officials do about legal outcomes. And by extension, they will therefore care about the determinants of legal outcomes, the political leanings of the judges. Now, the reason I think that the people who serve on these merit commissions might care about legal outcomes is because merit systems are distinctive from the other forms of judicial selection in the way in which they give a very large role to lawyers to decide who becomes a judge. And so Professor Ware mentioned this in his presentation. I'm going to go over it a little bit here again. This is a chart that shows by law, how many lawyers are required to be on the commissions that select names to send to the governor. And as you see, at the very top of the list is my home state of Tennessee, where 82% of the people that serve on the merit commission are required by law to be lawyers. Required by law to be lawyers. And in the vast majority of the merit states, a majority of the commission members must be either lawyers or judges. So the distinctive feature of the merit system is that lawyers have a larger role in this system than in the other systems. Now, as Professor Ware explains, these are not just any lawyers. Lawyers are a dime a dozen. We can find a lawyer who believes anything we want to and put him on the commission. So if we wanted to find a balanced commission of political views or others, we could find the lawyers to do it if we really wanted to. But we're not just picking any old lawyers for these commissions. A lot of times what we're doing is we are picking lawyers that the bar wants on the commission. So it's not lawyers that, say, the governor wants, it's lawyers that the bar wants. And so what this chart is this is a chart, again, both these charts are data from the American Judicature Society. And so this chart here shows the number of the lawyer spots on the merit commissions that are controlled by the bar. And what I mean by controlled here is two things. So sometimes the bar gets to directly pick the people that go on the merit commission. So the bar gets a certain number of spots, and sometimes bar leaders pick the people who go to those spots. Sometimes the bar members vote on who gets those spots. they directly put these people onto the commission. In other situations, the bar has indirect control who gets on to the commission. So in my state of Tennessee, for example, all the people that go on the commission are selected by the speakers of the state legislature. But for 12 of the 17 members, 12 of the 14 lawyer members, the speakers can only put people on the commission that have been nominated by 5 bar associations. Tennessee Trial Lawyers Association, Tennessee Criminal Defense Lawyers Association, et cetera, et cetera, et cetera. So these are spots that, these are lawyer spots the bar gets to select who the lawyers are. And so you see again, in the majority of the merit states, the lawyer positions, at least the majority of the lawyer positions, are controlled either directly or indirectly by the bar. Now, I will note something here, and that is in my draft paper, I used the word bar associations, and I read Justice Stith's excellent article, and I realized that by using the word association, that has some connotations for some people that they don't have for me. What I mean by controlled by the bar is simply these are bar-selected lawyers. Whether you want to consider the Missouri bar as an association or not is irrelevant. These are bar-selected lawyers rather than lawyers selected by, say, the governor or other elected officials. And so the question is a system like merit selection that depends so heavily on lawyers to do the selecting, is this a system where the people doing the selecting are going to care about legal outcomes? And I think the answer to this is yes. Yes, number one, lawyers have political views like all the rest of us. And they want to see those views vindicated like all the rest of us do. But even more importantly than that, lawyers practice before these very judges that they're selecting. Some of these lawyers, their livelihoods are wrapped up quite heavily in what kind of rulings these judges make. If you're a plaintiff's lawyer, how easy it is for you to sue and how big your damage awards are going to be is very important to you. I think it would have to be superhuman if your livelihood depended on who the judges are, not to care about what kind of decisions the judges might make. And so I'm skeptical of the claim that by relying on lawyers to do our selecting for us, that we are going to eliminate any consideration of legal outcomes and thereby the political leanings of the judges, which we know influence those outcomes. So the bottom line for me is I think it's impossible to eliminate or reduce politics in judicial selection because politics matters to judicial decisions, and the only people we're going to ask to make the decisions are going to care about the results of those decisions. And I think the better question is not whether politics is playing a role or how much of a role politics is playing. The better question really is whose politics is driving judicial selection. And when we go to these merit systems, the politics driving judicial selection is going to be the politics of the Merit Commission. And it's going to be politics that, as Justice Scalia called in one of his dissents, he called the politics of the lawyer class. Merit selection is selection by lawyers, and the politics of merit selection are therefore going to be the politics of the lawyer class. And so one of the things that I want to end on here in the last 5 minutes that I have is to examine the implications of a system of selection that relies on the lawyer class to do the selecting. There are a lot of people that believe that lawyers are different from the rest of us in many ways, but in one way in particular. A lot of people believe that lawyers are more liberal than the public at large. And so, that was the context in which Justice Scalia uttered his quote about the lawyer class. The lawyer class has much more liberal views than the rest of us. A lot of people share these views, that lawyers and bar associations in particular are more liberal than the public at large. I looked around and didn't find any empirical evidence one way or the other. No one's done any sophisticated surveys of lawyers in the general public to determine whether it's conventional, what I think is conventional wisdom, that lawyers and bar associations are more liberal than the public at large. Nonetheless, if this conventional wisdom is true, it suggests the possibility that one of the effects of turning to merit selection is that we end up with judiciaries that are more liberal than judiciaries that the public would select on its own. And so one of the things that I did for this paper was I tried to gather a little bit of data to see whether there's any support for this notion that merit systems translate into political preferences that are more to the left of the public at large. And so what I did was I got a list of all of the people that the Tennessee Merit Commission had nominated to the appellate courts since it took its current form in 1995. And we gathered data on each of these nominees. There have been 90 nominations since 1995 to the appellate courts in Tennessee. And we gathered data on what the party affiliation was of each of the nominees. And the way we did it, Tennessee is an open primary state, so you don't register by party. They do, however, record which party's primary you vote in. So if you vote in Democratic primary or Republican primary, they record that. So we looked at whether you voted in more Democratic primaries or Republican primaries, and then we coded you a Democrat or Republican for each of these nominees. And so what we found in Tennessee is the following. So the blue line here is the percentage of Democratic nominees by the Tennessee Plan Commission since 1995, and the red line below it is the percentage of votes the Democratic candidates received in state house races over that same time period. And if you look over the entire 14-year time period, what you find is that 67% of the appellate commission nominees have been Democrats, and over that time period, only 50% of the House votes have been Democrats. And so, there's a lot of caveats I make in the paper. I've only got 2 minutes, so I can't go through the caveats of, we have to take these charts with a grain of salt for lots and lots of reasons. But at least, as a first cut, there's some initial data here which suggests that there may be something to the notion that relying on lawyers to do our selection tilts our courts a little bit to the left. I try to do the same thing in Missouri. Missouri is a little bit harder to do because not only do you not record voter registration, you also don't record the primaries of people voting. So what we did instead is we looked at campaign contributions. And this is an especially bad measure of party affiliation because there's all kinds of reasons why you give campaign contributions besides simply you agree with someone. In addition to that, a lot of people don't give campaign contributions, what we found. And so we only found campaign contributions for about half of the Missouri appellate nominees since 1995, the same time period here. And what we found was a similar trend that the Missouri Plan nominees, the half that we had data for again, and half we have no data at all, so that's a big caveat here. They also tilted a bit to the left. Over the 14-year period, it was 88% of the nominees were Democrats, and only about 51% of the House vote went Democrat. And I also broke this down depending on what kind of governor was in the state house, because a lot of people think these commissions kind of defer to the governor in looking at what kind of nominees to send. And again, when there's a Democratic governor in Tennessee and Missouri, they seem to be getting a lot of Democratic nominees and only a few less so in years when there was Republican governors. But they don't send Republican slates in either case. And so I see my time is up, so I just really offer this not to try to prove anything. Because again, you can read the paper. There's tons of caveats about relying on this data, especially in Missouri. Half the data is missing, and so we have to be very careful about drawing conclusions from that. I really offer this data just to provoke some thought, which is that when we rely on lawyers, there might be some good aspects of doing that. Lawyers know what judges do better, and so we might think we get a more accurate picture of what judges do by relying on lawyers to be selected. But there may be some negative consequences to relying on the lawyer class to select as well. We may get judiciaries that are out of step with the public in one particular political direction. And we can talk more about that during the question and answer and comment period, I'm sure. Thank you very much.
My thanks also to everyone who's put this together. It's just been a fascinating discussion today, and I know we're all going to look forward to reading in more detail the written remarks when they come out in the law review, which will be in this late spring, I guess, or summer. In summer. We'll look forward to it. It'll be great. There's not enough time for my co-author of my written remarks to speak here with me today, but he is here in the front row, Jeremy Root, and I want to thank him for his work on the remarks. My remarks today will focus on why the Missouri Nonpartisan Court Plan combines the best elements of the other methods of judicial selection while minimizing their pitfalls. A small but vocal group of critics, including some who we've heard from today, nonetheless have taken aim at nonpartisan selection and argue it should be rejected in favor of contested elections, this morning that was suggested, or an appoint and confirm system, similar to the federal model, but without the federal protection normally of life tenure. Some have even argued that judges should be chosen not on merit, but rather on whether they share the views of the popular majority or of the ascendant political party of the moment. As I will discuss, these arguments are based on a misunderstanding of how judicial selection in fact works in Missouri and how it works under the systems the critics espouse to put in its place. As Alexander Hamilton wrote in Federalist 78, the complete independence of the courts of justice is peculiarly essential in a limited constitution. Missouri's approach to judicial selection accomplishes this objective. It recognizes the only promises judges should make are first, to decide cases fairly and impartially, and second, regardless of their own personal views or the views of the voters, to follow the law. But what is the best way to select judges that understand this important and independent role? The U.S. Constitution does not require the states to follow the federal system, but rather leaves that decision to the laboratories of democracy, the states themselves. The unique history, culture, and experiences of each state have led them to adopt a variety of judicial selection systems that generally fall into one of three categories, as discussed earlier: contested election, political appointment, or merit selection. As you've heard earlier today, Missouri has tried all three methods, beginning with gubernatorial appointment when it became a state in 1821. The state switched to a popular election with the 1850 Constitution because citizens were concerned that the appointive system gave one person all the power without an effective check. But by the 1930s, Missouri's elective system too became corrupt. The most famous example, which the Justice mentioned this morning, was the notorious political machine controlled by Kansas City Democrat boss Tom Pendergast. As earlier speakers have mentioned, a group of citizens, politicians, and lawyers eventually became sick of this kind of political corruption and proposed adoption of a nonpartisan court plan under which judges would be selected based on merit, using the best elements of both the appointive and the elected systems. They did so because, as one commentator has put it, while it is true that partisan elections make judges directly accountable to voters, reformers at the time were more interested in making judges more independent of legislative influence. Now, many states that later adopted a merit selection system did give legislators a role, as we've heard today. This makes sense, for in those states, the merit system was adopted through action of the legislature, either by statute or through a referendum process. Naturally, a system that the legislature created would give legislators a role. While understandable, this does make the selection process more partisan because legislatures, governors, and other politically elected officials are naturally partisan. But Missouri's experience is different. In the late 1930s, Missouri Republicans asked the legislature to adopt a nonpartisan merit selection system because they believed the Democrats who controlled the governor's office and both chambers of the legislature had improper influence on judicial elections. The legislature, not surprisingly, refused to act and thereby take power from itself. So, led by the original Rush Limbaugh, grandfather of the well-known political pundit, the people took charge and did it themselves. Through the initiative petition process, they voted to adopt Missouri's merit selection system. The Democratic-controlled legislature did not like being cut out of the system and tried to repeal the nonpartisan plan 2 years later. The people voted to keep it by an even larger margin and reaffirmed it during their constitutional convention a few years later. Recently, attempts to inject partisan politics into the plan were unsuccessful in Missouri's legislature. An attempt to repeal the plan by initiative did not even make it past the signature gathering point. And Greene County, located in Missouri's conservative southern section, voted in November to adopt the plan on a local level. So how does Missouri's nonpartisan commission work? It's geographically diverse, being composed of a judge of the Supreme Court, a lawyer elected in competitive elections by his or her fellow lawyers from eastern, southern, and western districts of Missouri, and a non-lawyer appointed by the governor from each of these 3 districts. The people intended that the lawyers evaluate the applicants on their legal abilities and that the lay commissioners consider the applicant's character and community values. The lawyer and non-lawyer members serve staggered terms of 6 years each, so no governor or political wind of the moment can influence the commission and the individuals they nominate. The judge member serves only during the time he or she is Chief Justice, in Missouri a term of 2 years, so the judge can provide insight into what the courts need, but cannot have undue influence. Once the commission nominates, the governor then has 60 days to select which nominee will serve the people of Missouri as judge. Then, after the judge has served at least 1 full year in office, a probationary period, the judge must stand for retention at the next general election before beginning his or her first full term in office. Some have criticized the presence of 3 lawyers on Missouri's nominating commission. For example, Professor Fitzpatrick writes in his article that he fears this allows the organized bar to control the selection process. Similarly, the brochure for today's program states that lawyer commissioners are appointed by the organized bar in Missouri. Now, there's nothing wrong with involving the organized bar in selecting commissioners, as many states do, but that's not actually what happens in Missouri. Our Constitution clearly shows that the organized bar has no role whatsoever in the selection of judges in Missouri. Unless, of course, somebody thinks the fact that lawyers must be members of the bar to practice law counts. As we all know, however, and lawyers tend to kind of disagree with each other and can't all be put on the same side of the bench. And as I mentioned earlier, the lawyer members are chosen in a democratic fashion by direct election of their fellow lawyers. But to be fair, I think that the larger point that Professors Ware and Fitzpatrick are making is they're concerned about the influence of lawyers on the process generally. And Professor DeBow says lawyers have, as I understand, an inherent conflict of interest because they appear before judges, and that was said earlier too. And they all seem to argue that lawyers are just too darn liberal. I believe, however, that my friend and former colleague Steve Limbaugh, who until recently was on my court, and many of the other judges selected under Missouri's nonpartisan plan over the years, would disagree, including the 7 Supreme Court judges who were selected in the late 1980s and early 1990s by Governor John Ashcroft. Yes, that John Ashcroft, who was later appointed U.S. Attorney General by President Bush. One of Governor Ashcroft's appointees, Ray Price, is still on the court and will succeed me this summer in his 2nd term as Chief Justice of Missouri. In any event, studies of campaign donations by so-called liberal law professors and similar studies cited by opponents tell us very little about the views of average lawyers. First, the donations of professors may be influenced more by the fact that they are in academia than by the fact that they are lawyers. And second, there are many fine conservative professors who are lawyers also, including some you've heard from today, and of course, Mizzou's own Carl Esbeck. And in any event, Professor Fitzpatrick, your argument that Missouri judicial candidates contribute more to Democrats, 89%, than the average voter votes for Democrats in Missouri's House, 50%, I don't really think holds water on closer inspection. One thing we haven't looked at, or it doesn't show at least in the chart, is how many judicial candidates also gave to Republicans during that period. But leaving that aside, out of the 108 judges nominated whom your chart indicates you studied since, since 1994, you said only 52 of them actually gave money to Democrats. 55 117th is 48%, not 88%, even using new math. Moreover, Supreme Court judges run for office statewide, not by House district. If you look at the number of Democrats elected statewide from 1994 to the present, there were 23 compared to 8 Republicans, or about 75%. Now, I'm not citing these statistics to you in order to convince you that Missouri judges are more conservative than the average Missourian, although that is what those particular numbers would seem to show. Rather, my point is that statistics like this are meaningless. Anyone can play with numbers and come up with some that fit their thesis. Let's look instead at why lawyers are on selection commissions and what purposes their presence serves. Having significant input from lawyers is necessary to identifying whether the applicants possess the competence and experience they require to perform their judicial functions, just as the lay members provide invaluable input as to the applicant's character and personal qualifications. In fact, one of the reasons Missouri adopted the plan to begin with was because a pharmacist got elected to the trial bench in St. Louis. He had a law license, but he had never practiced law. Similarly, Missouri law provides that other kinds of professions, pharmacists, accountants, architects, engineers, chiropractors, dentists, all are governed by boards that have one lay member, and the rest of the board is made up of members of the profession they're judging. So of course you need lawyers on a commission that's judging other lawyers. It's just common sense. In fact, the input of lawyers is so essential to judicial selection that they're part of all such systems. In the federal system, for example, the qualifications of a judicial nominee are reviewed by the Senate Judiciary Committee, which is made up of lawyers, because they understand whether the nominee is well qualified or not. In an elective system, lawyers and their clients are the biggest contributors to judicial candidates, and those who gave the most are suspected of having done so in an attempt to win just a little influence with the judge, just as do other interest groups trying to influence other elections. In all these other systems, though, it's only small groups of lawyers, either those who can afford to give large sums of money or those who are in the legislative body or interest groups, who have the influence. Not so in a system like Missouri's. The lawyer membership of the commission is determined by the vote, by the vote of rank and file lawyers. Majority wins. Sometimes there's even a runoff. And as set out in some detail in our article, those commissioners reflect a wide variety of backgrounds and viewpoints, not merely those of plaintiffs' lawyers, as has been so popularly but inaccurately suggested. The same is true of Missouri's judges. Some have also suggested that the Missouri plan is less desirable because the presence of a majority of lawyers or judges on the commission makes the system elitist rather than populist. Well, first, I'm not clear some of these commentators why they found their arguments in populism without going on to suggest that Missouri should adopt contested elections. While clearly the latter are more populist, direct elections carry with them the very risks of corruption that led Missourians to adopt the nonpartisan court plan in the first place. This is because as judicial campaigns become more expensive and people and organizations with a regular stake in courts and court outcomes make significant financial contributions to those campaigns, it's not hard to find or to fund what amounts to at least an appearance of impropriety. We've already today heard much about the egregious example from West Virginia, where the CEO of a company gave more than $3 million to a lawyer running for election in the state's high court. Sounds like it would be a good Grisham novel, doesn't it? We've heard about Illinois, and there's innumerable other examples. In all those states, the court's decisions in cases involving the contributors have been criticized, would be a mild word. I believe that my fellow panelists agree that these are not scenes we want repeated in Missouri or elsewhere. Professor Ware suggests that the appoint and confirm system is next most populist. Of course, the people actually have no vote of any kind in that system, but he says they do elect their governors and senators, and so if we let the governors and senators then select the judges or commissioners, it's the next most populist indirectly. By contrast, Professor Ware describes Missouri's system, I apologize for my cold, describes Missouri's system as elitist, although in doing so, he admittedly chooses to exclude a critical factor of Missouri's plan, that the citizens kept for themselves the right to vote on whether that new judge is to be retained in office. There are two reasons he nonetheless believes his approach is reasonable. First, he suggests that this public retention vote can be ignored when considering judicial selection because it occurs after the selection process is over. But that's not true in Missouri. While most commentators focus their attention on the first and second stages of judicial selection in Missouri, the initial retention vote of the people is the critical third and necessary stage of Missouri's selection process. Before that, the judge is only serving during a probationary period to give Missouri voters the opportunity to confirm whether they agree with the work of the commission and the governor in selecting the judge after reading detailed judicial evaluations. If the voters were to reject the nominee, he or she would never begin his or her first full term in office. And Missouri is not alone in this regard. Approximately a dozen states hold a similar retention vote early in the term of the judge as part of their selection process, in addition to requiring regular retention votes at periodic intervals thereafter. Some also argue that retention elections are meaningless because most judges are retained. Again, I see two problems with that argument. First, far from being a valid criticism of the nonpartisan plan, The fact that most judges are retained, to me, shows how well the system works in ensuring well-qualified ethical judges are selected. Nominating commissions, governors, judges, all of them know that they must do their jobs fairly and properly, because if they do not, and a nonpartisan judge shows himself or herself to be inappropriate for that office, the people can vote him out. Second, if the criterion of a successful system of selection of judges or of any other leader is how often our leaders are turned out of office, then I understand why the contested election system is no one's choice. During each election cycle, we hear time and again that more than 90% of incumbent politicians are reelected. In Missouri, judges in our smaller communities are still elected by popular vote too. It works well here, for unlike in larger communities or statewide, everyone knows each other and the public is familiar with the judge's reputation. And like others who run for office, nearly all judges running for re-election in contested campaigns are successful. In fact, most of them do not even draw an opponent after they win their first race. The popular election system, therefore, gives voters less choice than does the retention system. As one of our former partisan elected trial judges has said, if people in my county didn't like me as judge, they had a vote but no choice, because for 27 years nobody ever ran against me. At least in retention elections, the voters get a choice to vote yes or no to retain a judge. And very importantly, far from being elitist in character, the nonpartisan selection of judges has led to greater diversity on Missouri's bench. In 1992, women made up from 8 to 10% of the bench at all levels of our state judiciary. Women now make up some 20% of Missouri's bench, but that number is not evenly distributed. Women still are only 13% of Missouri's elected judges, but make up a full 32% of judges appointed under the nonpartisan court plan. The comparison for persons of color is even more startling. To my knowledge, only one Hispanic and one African American judge have been chosen in a contested election in Missouri in the last 30 years, while persons of color serve on all of our appellate courts, the trial courts in St. Louis and Kansas City, and until very recently on our Supreme Court as well. What does all this tell us? Well, there may be no perfect single way to design a system for selecting judges, but no system works better at keeping partisan politics at bay than the Missouri nonpartisan court plan. It's impossible for this plan or any plan to be completely apolitical. Under the Missouri plan, the governor gets to select the commissioners and the final choice for judge. But the people, brilliantly I think, set up the plan to avoid the kinds of partisan political fights we see in the U.S. Senate over confirmation of a nominee, for the governor is the only politician involved. And acting through their retention vote, the people get the final say as a check on both the commission and the governor. This system has served Missouri well for nearly 3/4 of a century and will continue to do so into the future. In the words of Justice Stephen Breyer, the reputation and reality of the fairness and effectiveness of the American judicial system are in the hands of the states. The Missouri nonpartisan court plan has done its part to keep up that reputation and to preserve both the perception and the reality of fairness. Thank you.
Hi, it's the hardcore that's left. I'm honored to be here. Let me repeat just briefly my thanks for the hospitality of the law school and particularly the law review staff. It's been a wonderful event. I think you've had a very wide range of views presented here today, and I think that's a credit to the people who organized the program. Just very briefly, I'm from Alabama. I'm not here to tell you what you should do in Missouri. That should come as a big relief. I got interested in this subject 15 years ago because of what was happening in my home state. It's a long story. One short version of it would be that the punitive damage practice, particularly in tort and some contract litigation, had sort of come off the rails to the point that Alabama was routinely castigated in the Wall Street Journal and so on as tort hell. The voters noticed this and made a radical change in the composition of the state Supreme Court. I viewed this as a positive development. What happened shortly thereafter was that there were a number of proposals to reform judicial selection in the state and make it non-elective. And I thought the confluence of the two events was probably pretty telling. And I began to look at the political science literature on the question of judicial selection. And I read articles by quite a few of the people on this program, and it's been fun to meet them and put a face to the name and hopefully make sure that I'm citing them correctly. And all I ever did was line up the political science material that said, you know, if you look at judges in elective and non-elective states, you really can't find much in the way of evidence that one set of states has better or more qualified judges compared to the other. And so what tends to happen is that we oversell our position in these arguments. And so I'm actually not here to convince you of anything today. I'm here to, I've learned, I think, quite a bit about the Missouri plan and how it actually works, and I've got a couple of questions based on the panelist papers. And so everything, I'm going to try and put almost everything I say here into the form of a question, and I am going to be brief, and I'll just take the papers seriatim, I guess. I think Steve's taxonomy of selection systems is very helpful in thinking about the alternatives, and it does raise a significant question about the degree of I'll say lawyer domination of selection commissions, the extent to which lawyers either predominate in terms of numbers or because of their expertise could be expected to control the agenda and set the tone for the lay members of the commissions. I thought his distinction between hard and soft Missouri plan states was interesting. And as I thought about it, it seems to me like there's at least two possible bases for concern about lawyer domination of selection commissions. And again, I just raised these as questions. Lawyers' ideology has been mentioned and discussed in the presentations, I think, pretty thoroughly. I don't have anything to add to that. I think the lawyers' self-interest in lawyers as a group now, self-interest in lawyer incomes and litigation rates is worth some more thought. Looked at from the point of view of non-lawyers, the fact that the number of lawyers goes up and lawyer incomes go up consistently. We have more laws, more regulations. Law becomes a more important feature of our lives. This has been true for at least 50, 60, 70 years. Pick your time. A lot of people think that's a positive development. Others aren't so sure. You can find people on both sides of that debate pretty easily. There's a book that I just recently discovered. Lawrence Friedman, the legal historian at Stanford, wrote a book called Total Justice in 1994, where he said there's increasingly an expectation of justice and an expectation of recompense for all loss and injury. And there are people who would applaud that. There are other people like Philip Howard. I don't know if you're familiar with this fellow. He's a partner at Covington. Has recently written a book called Life Without Lawyers. He has a group called Common Good, and he thinks we have way too much law. Well, lawyers are going to tend to think that an increase in the amount of law and litigation in society is generally a good thing. I don't want to argue that one way or the other today. I just want to point out that lawyers have a self-interest in that question that may well lead them to a different opinion about law and litigation versus other forms of dispute resolution and other social institutions that will skew the work of selection commissions. So my question is, and it's kind of simple-minded and obvious, I guess, but what would happen in a Missouri plan state if you reduce the power of lawyers on the commission? I completely understand that the lawyers are in a much better position to evaluate candidates' careers and performance either in practice or on the bench, and so lawyers have a great deal to contribute, but they don't have to vote necessarily on the recommendations to the governor. I mean, you could have non-voting lawyer members on the commission or some small number relative to the whole. I mean, is there some way to to change this so that the lay people dominate the commission and the lawyers are basically in an advisory mode. And related to that, I wonder what would happen if you had the lawyer members on the commission identified so that the lay people would know who they were, of like, I'm from the defense bar, I'm from the plaintiff's tort bar. Would that help? Would that?
They've had big spots for
Oh, okay. I don't. I'm a stranger here myself. I don't know your system, so I'm just wondering if you had people labeled, does that defeat the nonpartisan aspect of it, or does nonpartisan? Well, I don't know. I mean, does nonpartisan mean party identification only? This is another simple-minded question. I think we conflate. Do we mean Democrats and Republicans, or do we mean trial or defense or whatever? So anyway, that's a thought. Reduce the power of the lawyers on the selection commissions. I also love it that Steve has identified a new field of research for everyone, which is selection committee selection. I think I urge everybody to look into that, contribute to that literature. Brian's incorporation of legal realism into the debate is something I hadn't thought about all this in that light particularly, and it's one of those things that after someone points it out, you go, well, yeah, that's an obvious point, and I mean that's the highest praise I think I could give it. The idea is that we're all realists now except when we're talking about judicial selection, and I think that's really a very interesting point. I would ask how important is the counter-majoritarian difficulty with regard to state constitutions and litigation under state constitutions. I don't know the answer to that. I'm basically a business lawyer, a teacher of business law anyway. Maybe that's the last decade's news, and I'm a little behind the times. I don't know. Justice Stith's paper, again, was a source of a lot of additional information for me about how it actually works here in Missouri. It's a very interesting paper. I do have to note the irony that the lawyers on the selection commission are popularly elected by their peers. Ever thought about selecting them with the selection commission? Right, I mean, how far down do you want to go with the idea that elections are not a proper way to evaluate candidates for things? And she winds up her paper talking about the Aristotelian mean, and I appreciated that. It reminds me too what we're arguing about here today, and the reason we're not going to come to any conclusion is we're also arguing about the age-old question of who guards the guardians. I don't know how to pronounce all that in Latin, but that's what we're looking at is either Socrates or Plato. I don't know. Let me leave you with one last quote, if I have a minute. Okay, great, perfect. Tolstoy once famously observed that all happy families resemble one another, but that every unhappy family is unhappy in its own way. If there's no judicial selection mechanism that's perfect, then maybe every state is unhappy and in its own way. Economists call this path dependence. If each state is simply at the end of its own unique historical path, this would explain the difficulty of reform of judicial selection, and also the difficulty of making, absolutely rock solid and compelling systemic judgments among the competing systems. But it's certainly been a pleasure and an honor for me to listen to the discussion today about all of this. Thank you.
I too will join with my thanks to the Law Review for the absolutely spectacular conference. I'm empowered by the fact that I have the last word and frightened by the fact that I'm all that stands between you and cheese and wine. Therefore, I will try to be reasonably brief. I particularly appreciated the Ware and Fitzpatrick papers because they captured a fear that I intuitively have always had, and that is a suspicion of lawyers. And I was sort of nice to have lawyers suggest that. What I would like to do, we tend to be very ethnocentric in how we look at things. And in the U.S., every Missouri plan is a certain number of lawyers, judges, and lay people. The Missouri plan is generally called in the comparative sphere judicial appointments commissions. And it is the most popular system adopted by all of the new democracies in Eastern Europe, a number of re-democratizing countries in Latin America, and most recently by England, Wales, and Scotland. And since we in the U.S. created judicial review, we created judicial elections. Actually, we didn't. The French dealt with them very briefly, used them briefly after the French Revolution, and quickly jettisoned them. However, they have recently been readopted in the 2008 Constitution of Bolivia by populist President Evo Morales. So please tell Justice O'Connor, I don't know if they've gone into effect yet, but there will be elections until the next coup in Bolivia. But as we have exported things, our innovations to other countries, maybe they may have improved and tinkered with our ideas. And so I thought it might be useful to do a quick survey of how merit retention, or as they call it, judicial appointments commissions, have been sorted out in the rest of the world. And notably, none of them use a retention election. All of them carry life tenure to a mandatory retirement age. The oldest one outside of the United States is that of Israel, which was begun in 1953. And in that case, in Israel, the commission does not nominate to anyone. The commission selects the judges. And their commission, for all levels of court except the Supreme Court, includes the President of the Supreme Court, 2 other Supreme Court justices, the Minister of Justice, equivalent to our Attorney General, 1 cabinet minister, 2 representatives of the Knesset, their legislature, 1 of whom is always from the opposition, and only 2 representatives of the Israeli bar. Bulgaria, Lithuania, Poland, and Romania have all adopted a judicial appointments commission, and all of them use some combination of legislators, lawyers, you'll like this one, law professors, what a novel idea, and judges. Latin America, at some point since 1980, judicial appointments commissions have been used in Argentina, Bolivia, Colombia, Costa Rica, Ecuador, Guatemala, Mexico, Panama, Paraguay, and Venezuela. The Venezuelan case is particularly important. It was created in 1969. It became so politicized that it was eliminated in 2000. South Africa, their new post-apartheid constitution, includes judicial nominating commission. The criticism there is that it's totally dominated by the African National Congress, and therefore a number of qualified jurists will not apply. It's been used in Namibia. It has been since 1995. Now, Zimbabwe has a system that only Governor Pendergrass could have loved. Zimbabwe has a commission that recommends to President Mugabe. You may be familiar with Robert Mugabe. He has the perfect system. He appoints the majority of the commission, and therefore he only gets candidates that they know would be appropriately acceptable to him. But he has a fail-safe system. In the event that he wants to remove a judge, he can appoint a commission to investigate the judge to remove him. This is one that only a dictator could love. Scotland adopted in 2005 a judicial appointments commission for all courts. It consists of 5 lay people, 2 members of the bar, and 3 judges elected by other judges. 2005, they also began the Judicial Appointments Commission for England and Wales. They have a 15-member commission that makes recommendations to the Lord Chancellor, the Attorney General. 3 judges, 1 from the High Court, 2 from Courts of Appeal. The chair and the other 11 members are not restricted as to what occupation or profession, but rather there's an independent commission to whom you apply, and the independent commission names both the chair of the committee and the other 11 members of the panel. The United Kingdom will institute a Supreme Court October of this year. It will still not have the power of judicial review, but it will replace the old House of Lords Judiciary Committee. And it will take the current House of Lords Judiciary Committee and they become the Supreme Court. But when vacancies occur in the future, replacements will be determined by the President and the Deputy President of the Court, members of the Judicial Appointments Commissions, which are those that I've just described how they were selected, from England, Wales, and Northern Ireland. Notably, no lawyers. They can nominate only one person to the Lord Chancellor, who may reject the candidate and send it back. But the Lord Chancellor is required to make a number of consultations that include with members of Parliament, with the Prime Minister, with other judges. Why is this such a popular system abroad when we're debating it so viciously here at home? Well, partially it gives the appearance of impartiality. In most cases, the executive has some power to reject commission recommendations. Best of all, it provides cover for executives. You can always blame a bad appointment on a commission. But it does give the appearance that litigants can believe that they are going to be treated impartially. However, studies of how judiciaries work around the world, if the two things we're looking for most are qualified judges and judicial independence, it's not how we select the judges that makes the difference. Study after study after study has found that if you have healthy two-party competition, rotation, alternation in power of the parties, you will secure an independent and qualified judiciary. I believe that's what we have all strived to talk about today, and the former justice gave us so much. I believe that Missouri, the simple popularity of the Missouri plan in part abroad, confirms what Justice Stith said in her paper. Thank you, Missouri, for this gift to the art of governance. Thank you.
Fortunately, no one said anything controversial. There should be no questions that we can end. Now we have to take a few minutes for questions. There's just too much out there. We are a little bit over, so we'll try to keep it brief, about 10 to 15 minutes, but into you, Mr. Shaw.
May I question whether Steve's taxonomy is helpful? In order to be concise, I jotted notes as the panel proceeded. You treat egalitarianism as a great value, and I agree with you in part. Egalitarianism is not the only great value, and elitism is as plain a put-down label as one could come up with. Our system does not exalt egalitarianism uber alles. We recognize other great values, which for simplicity I'll call deliberativeness. The United States Senate is not elitism. We have a republic, not an egalitarian majoritarianism. We have structures like the Senate. We have devices like presidential veto, and like judges who can strike down the actions of other branches when necessary to protect constitutional rights. In short, we have both egalitarianism and mediating structures and devices to assure what, for shorthand, I'll call deliberativeness. May I suggest that going for egalitarianism uber alles and using a misleading label, elitism, ignores the nation's history of rich flexibility and creativity. With a system like the Missouri Plan, just a significant example of our ever-evolving, innovative checks and balances. Your radicalism is questionable.
I'm not sure I got the question.
Answer. What's wrong with what I just said?
Well, to keep it short, elitism and populism, according to my dictionary, have sort of neutral, descriptive meaning of populism giving power to the populace, elitism giving power to elite. The bar lawyers tend to be more knowledgeable about this topic, tend to be higher income, higher education, elite under the standard understanding of what that term means. And I think you and I agree in so far as I said up there and say again now, I don't think going either to the populist extreme or the elitist extreme is the way to go. I consider myself a moderate on this issue and that I see value to populism and to elitism, and I'm trying to strike a happy medium.
I can't add to what I just said. Yes.
Hello, panel. I'm Kristen Hogan. I'm the executive director of Springfield Metropolitan Bar Association and the lawyer. Springfield is in the now apparently relevant Green County, Missouri. And yesterday, just yesterday, the results of the 31st Circuit Judicial Petition were announced, the numbers. And I was intrigued by Mr. Fitzpatrick's contention about control by the bar. With my 828 members, the idea that they would all walk in lockstep is will only make the job infinitely easier, and it's certainly not the case. And also, I am not in academia anymore. I'm just in very much real life in the Ozarks. And the other contention that somehow the results of nominating committees being left to center. I think that if you were to do some research in Greene County, you might find that our statistics might exceed that percentage.
So, it doesn't matter about anywhere in rural Missouri. You don't have to stop at Greene County.
I didn't mean to imply that all lawyers believe the same thing. I certainly, of course, I'm a lawyer and I'm conservative, so I know that's not the case. My simple contention was that a lot of people believe that on average, lawyers are more liberal than the public at large. Now, whether that's true or not, I tend to think it is. Most people I know tend to think it is. I'm sure there's some people who disagree with that. I'd love to see some good empirical work in this area. On the question of the committee in some areas of the state, I'm sure that things vary around the state. The charts that I were presenting here were just the appellate commissions. I understand the one in Greene County is a trial commission. Is that right? For trial courts. Yeah, I was with appellate courts. And so, it could be that in conservative parts of the state, the commission is going to be turning out more conservative nominees. But of course, we've got to look to what's the electorate preferences in that part of the state as well. So it's 50-50 in Missouri overall. What is it like in Greene County or the more rural areas? Is it the 50-50 areas or those areas 80-20 like they are in some parts of Tennessee, et cetera, et cetera. And so we have to make sure we're comparing apples to apples and oranges to oranges. Certainly, I agree.
Come on down, we're happy
I don't want to shift the attention from Missouri, but I'm a lifelong Tennessean who could not forgive myself if I did not point out that in many parts of our state, you don't vote unless you vote in a certain primary. There simply are no candidates in the other primary. So if you set about to categorize whether our appellate judges are D's or R's based upon which primaries they voted in, you have started from a flawed beginning. And I think it's just unfortunate if anyone leaves here thinking that which primary you vote in Tennessee means anything other than that you really want to exercise the right to vote. Often we have no choice.
I think Professor White's absolutely right about that. All of these proxies are proxies. And some of them are weaker, some of them are stronger. I think the campaign contributions is especially weak for the reasons that I outlined. And there are defects with the primary voting as well. Some areas of the state are one-party areas of the state. And so you have to vote in those parties or you're not going to be voting in the primary. Of course, the data does include, federal primaries as well, where you typically do have a choice, for example, in the presidential primaries and what have you. But she's absolutely right. There are weaknesses to all these proxies, and we have to remember these things and take all of these things with a grain of salt. And there are many other caveats to the charts that are in the paper.
I'll ask a quick one, since all I know is what Judge Posner says. He says that those countries you described mostly have career judiciaries where you enter as a judge at a low level, particularly talking about Europe.
Those are the West European, where in France, Italy, Spain, Portugal.
Do they have nominating commissions like you described?
No.
Oh,
because
okay.
they have a career service.
Like I say, I only know the countries
Yeah,
that he talks
and
about.
no, this is only in the new democracies. And in Britain, the change, I mean, it's the new democracies or the re-democratized.
Also is it true what he consistently says, which is to constitutional courts in other countries, there's a one term for a fixed time like 8, 10, or 12 years. He consistently says that.
That varies. It's renewable in some countries, not in others.
He claims in Western Europe that he says that consistently. He has a new
The
Volcansek.
European Court of Justice is renewable terms. I believe that in the Federal Republic of Germany that it's also renewable terms. I know that it's not in Italy.
It's not important.
I know it's not in Italy.
One more. Well, if they're quick, 3 more. You're a Phil.
Okay, I think mine is fairly quick. It's for Professor Ware. Just as I think Professor Shotland did a kind of eloquent job of describing how you have blinders onto the derogatory nature of the term elitism in our political rhetoric. You can say that to you it doesn't connote that, but in the broader cultural context, it clearly has a negative connotation. My question though is about the virtues of populism as you describe them. It seems to me you're ascribing populism to legislative bodies, as though the legislative body is as pure a form of populism, not as pure as elections, but purer than a merit selection type system. And in light of what we know about the nature of partisan politics, and it may be that I'm just too cynical about the way partisan politicians act, but I don't believe they are always acting out of populist, best interest, will of the people virtues. And I wonder if your kind of 2 sphere models might ignore that.
Well, since it's a continuum, it's only one dimensional. It can only measure the degree on one thing, and so obviously adding more factors gives you a richer picture. What the one thing it measures is power of the bar, the extent to which a lawyer, just by being licensed to practice law, has greater power than his or her fellow citizens. And that's where the Missouri plan is at the extreme, in giving members of the bar more power than their fellow citizens.
Skip Walter, I'm president-elect of the Missouri Bar, and nobody shared with me where I get this power. But I have an important question.
When you vote for members of the nominating commission. That's the answer.
I do. Semi-humorous. I have a serious question for Professor Ware. Do you have any extra tickets for Sunday's game?
Apparently not.
I have a lot of questions and a lot of comments, but I will bring it down to one. Where is the scandal? Where is the scandal in Missouri? I mean, we know about the scandal in Missouri that started the nonpartisan plan. We know about the scandals in Texas and Illinois and other states that have that elect their Supreme Court and other appellate judges. Where's the scandal in Missouri? I don't understand what the impetus is, because to me, and I'll focus on appellate judges, the measure of how well the system works is its product. And the product is the judges. And the judge's product is the opinions. Where's the scandal?
Well, I guess I'll take the question because I'm not sure who it's directed to. I think egalitarianism, political equality, is a worthy value, even if departing from it produces no scandal. That's a contestable position. I understand that. Different people disagree on it. I also think openness of political government processes is an important value, even if departing from that produces no scandal. And so if you're going to keep a Missouri plan my, I guess, minimalist reform that I would have a plea for is have publicly recorded votes on each member of the nominating commission, who they voted for or against. So there's then information public can see, journalists and other citizens can see. Is it as nonpartisan and non-political as it's cracked up to be? You know, take the lid off the black box and see what's really happening.
Well, thank you so much. There's lots more to discuss.